If you hold a green card, if you're waiting for one, or if someone in your family depends on permanent resident status in the United States, you need to understand what just happened. New immigration legislation has passed, and while you won't hear about every detail in the mainstream news, the provisions buried inside this law will directly affect how green card holders live, work, travel, and maintain their status going forward. This isn't about speculation or proposed rules that might never take effect. This is law. It has passed. And the timeline for implementation is shorter than most people expect. I'm going to walk you through exactly what changed, who is affected, and what steps you should be considering right now. Not tomorrow, not next month, right now. Let's start with what actually happened and why this matters more than previous policy announcements you may have heard about. For years, changes to immigration have come primarily through executive orders, agency memoranda, and regulatory adjustments. These are important, but they can be reversed by the next administration. They can be challenged in court. They can be reinterpreted by agencies under different leadership. What makes this moment different is that we're talking about statutory law, legislation that passed through Congress and received a presidential signature. This creates a level of permanence and enforceability that policy memos simply cannot match. The provisions in this law will remain in effect until Congress passes new legislation to change them, which, as anyone who follows immigration knows, does not happen quickly or easily. The legislation itself is comprehensive, touching multiple areas of the immigration system. But for green card holders specifically, there are several provisions that demand immediate attention. And here's what many people don't realize. Some of these provisions affect not just future applicants, but people who already have their green cards. People who thought their immigration journey was essentially complete. Let me explain why that assumption could be dangerous. The first major area of change involves what's being called enhanced residency verification. Under previous law, green card holders were expected to maintain the United States as their primary residence. This was always a requirement, but enforcement was inconsistent. Officers at ports of entry had discretion. Patterns of extended travel might raise questions, but consequences varied widely depending on who you encountered and what explanations you provided. The new law creates standardized triggers for residency review. If you spend more than 180 cumulative days outside the United States in any calendar year, your re-entry will automatically generate a secondary inspection and a formal residency assessment. This isn't discretionary anymore. It's systematic. But this is where many green card holders will make a critical mistake. They'll assume that staying under 180 days means they're safe. That's not how this works. The 180-day threshold is a trigger for automatic review, not a safe harbor. Officers retain full authority to question your residency based on any evidence suggesting you've abandoned your permanent resident status. The difference now is that exceeding 180 days removes any ambiguity. You will face formal questioning. What does a formal residency assessment look like under the new framework? It's not a brief conversation at the immigration counter. You may be referred to a separate area. Your travel history will be reviewed comprehensively, not just your most recent trip. You'll be asked about your tax filings, your employment, your property ownership, where your spouse and children live, where you maintain bank accounts, where your driver's license is issued. And here's what most people don't understand about these assessments. The burden is on you to prove you haven't abandoned residency. It's not on the government to prove you have. If you cannot provide satisfactory documentation during this assessment, the new law authorizes officers to initiate removal proceedings on the spot and to cancel your green card status pending a hearing before an immigration judge. I'll explain exactly what documentation you should be carrying whenever you travel later in this video. The second major area of change affects what's called conditional permanent residence. And this has significant implications for people who obtained their green cards through marriage. If you received your green card based on a marriage that was less than 2 years old at the time of approval, you received conditional residence. You know this. You have a green card that expires after 2 years, and you're required to file Form I-751 to remove those conditions and obtain a permanent green card. The new law adds additional requirements to this process that did not exist before. First, the filing window has been modified. Previously, you could file the I-751 petition during the 90-day window before your conditional residence expired. Under the new law, you must file during a narrower 60-day window. Filing too early will result in rejection. Filing too late triggers automatic termination of status. Second, the evidence requirements have been substantially increased. The previous standard asked for evidence that your marriage was entered in good faith and remains valid. The new standard asks for evidence that your marriage was entered in good faith, remains valid, and continues to be genuine as demonstrated by ongoing cohabitation and financial interdependence. What's the practical difference? Previously, you might have submitted a joint lease, a few bank statements, and some photographs. Under the new standard, adjudicators are specifically instructed to look for evidence covering the entire period of conditional residence, not just a snapshot. They want utility bills from multiple periods. They want tax returns from both years of conditional residence. They want evidence of shared insurance policies, retirement beneficiary designations, and ongoing financial entanglement. If your marriage is genuine, this shouldn't be a problem, right? In theory, yes. But many genuine couples don't document their lives in ways that satisfy immigration requirements. They maintain some separate accounts. They have periods where one spouse traveled for work. They filed taxes as married filing separately for legitimate financial reasons. None of these things mean the marriage isn't real, but all of them now require additional explanation and corroboration. The couples who navigate this successfully are the ones who start compiling evidence now, not during the 60-day filing window. They're the ones who understand that immigration adjudicators aren't looking for proof of love. They're looking for paper trails that demonstrate integrated lives. The third area of change affects naturalization timelines and eligibility, and this is where the new law creates both challenges and opportunities. Let me start with the challenge. The physical presence requirement for naturalization has always been straightforward in theory. To naturalize as a general applicant, you need to have been physically present in the United States for at least 30 months out of the 5 years before you file. For spouses of U.S. citizens, it's 18 months out of 3 years. The new law doesn't change these numbers, but it changes how they're calculated and verified. Previously, physical presence was largely based on self-reporting. You provided your travel history, and unless something looked suspicious, USCIS generally accepted your account. Under the new law, USCIS is required to verify physical presence through systematic cross-referencing with CBP entry and exit records. Why does this matter? Because CBP records are not perfect. Data entry errors occur. System glitches happen. If you traveled through land borders, your entries and exits may not have been captured at all. And under the new verification requirement, discrepancies between your stated travel history and what appears in government databases will trigger requests for additional evidence, or, in some cases, denial of your naturalization application. This means you need to obtain your own travel records now. Don't wait until you're ready to file for naturalization and discover that the government's records don't match your recollection. Request your I-94 history. If you have global entry, review your trip history. Most importantly, keep your own documentation of every trip you take, including boarding passes, passport stamps, and entry receipts. Now for the opportunity. The new law includes a provision that many people are overlooking. For certain categories of employment-based green card holders who have maintained continuous employment in designated high-need sectors, the physical presence requirement can be satisfied in 4 years instead of 5, and the continuous residence requirement is similarly reduced. What are designated high-need sectors? The law specifies healthcare, particularly nursing and physician specialties with documented shortages. It specifies certain STEM fields tied to national security priorities, and it specifies infrastructure-related professions connected to current federal investment programs. If you work in one of these areas, you may be eligible to apply for naturalization a full year earlier than you expected. But you need to verify that your specific occupation qualifies, and you need to ensure your employer can provide the required documentation certifying your continuous employment in that sector. The fourth major area of change involves something that affects green card holders who aren't living in the United States at all, and some of them don't even realize they still have green cards. The new law creates a formal process for green card abandonment review that can be initiated by USCIS even when the green card holder is outside the country and has no immediate plans to return. How does this work? If government records indicate that a green card holder has not entered the United States in more than 24 months, USCIS is now authorized to send a notice to the last known address requesting evidence of intent to maintain permanent residence. If the green card holder fails to respond within 90 days or responds but cannot demonstrate intent to return, USCIS can formally terminate their status. Previously, the only way to lose your green card for abandonment was either to voluntarily surrender it or to be denied entry at a port of entry and have it taken from you. You could, in practice, maintain a green card indefinitely without living in the United States, even though this technically violated the requirements of permanent residence. That loophole is now closed, and here's what makes this particularly significant. When USCIS terminates your status through this process, it affects not just you, but any derivative applications or petitions that depended on your status. If you have family members whose immigration cases were connected to yours, those cases may be affected. Who is most affected by these changes? Let me be specific. Green card holders who travel frequently for business or family obligations face the highest immediate risk under the new residency verification rules. If your job requires international travel, if you have aging parents in another country, if you split time between the United States and somewhere else for any reason, you need to understand exactly how many days you're spending outside the country each year. Conditional residents, particularly those who obtained green cards through marriage, face increased pressure to document their relationships comprehensively and continuously. If your marriage has any complexity, any periods of separation, any unusual circumstances, you need to be preparing your I-751 filing now, gathering evidence that covers your entire period of conditional residence. Long-term green card holders who haven't naturalized face a more complicated calculation. On one hand, the new verification requirements make naturalization slightly more demanding. On the other hand, remaining a green card holder has become riskier. The enhanced residency requirements, the formal abandonment process, these all create vulnerabilities that naturalization eliminates. Once you're a citizen, your right to live in the United States cannot be questioned based on travel patterns. Green card holders living abroad, even temporarily, face immediate risk under the new abandonment review process. If you've been outside the United States for an extended period, you need to consider whether returning soon makes sense, or whether you should proactively address your status before USCIS initiates a review. So what should you be doing right now? Let me provide a framework for protecting yourself. First, know exactly how many days you've spent outside the United States this year and in previous years. Don't estimate, don't guess, calculate it precisely. Use your passport stamps, your boarding passes, your calendar. This number matters more now than it ever has. Second, if you're a conditional resident, start building your I-751 file now. Don't wait until your filing window opens. Gather documents from the entire period of your conditional residence. Joint tax returns, bank statements, utility bills, insurance policies, lease agreements, mortgage documents, photographs with dates and context. The more comprehensive your file, the smoother your process will be. Third, if you're eligible to naturalize, seriously consider whether now is the time. The new law has made permanent resident status less secure in some ways. Naturalization provides certainties that a green card cannot. This doesn't mean everyone should rush to naturalize, but it means you should make this decision based on current realities, not assumptions from 5 years ago. Fourth, whenever you travel internationally, carry documentation that demonstrates your ties to the United States. Tax returns, employment verification letters, property records, utility bills, evidence that your life is based here. You may never be asked for these documents, but if you are, having them immediately available can make the difference between a brief conversation and a formal residency assessment. Fifth, if you have questions about your specific situation, if you're unsure how these changes apply to your circumstances, seek qualified guidance. Immigration law is fact-specific. What applies to one person may not apply to another. General information like what I'm providing in this video tells you what questions to ask, but it cannot tell you what decisions to make about your individual case. Let me summarize the key points you need to remember from everything we've discussed. The new law creates automatic residency reviews for green card holders who spend more than 180 days outside the United States in a calendar year. These reviews can result in removal proceedings and green card cancellation. Conditional residents face a narrower filing window for removing conditions and substantially increased evidence requirements. Couples need to document their relationships continuously throughout the conditional residence period. Naturalization verification has become more rigorous, with systematic cross-referencing of government travel records. But new provisions also create accelerated pathways for certain employment categories. Green card holders living abroad face a new abandonment review process that can terminate their status even without them attempting to enter the country. Immigration law continues to evolve, and the implementation of these new provisions will create additional questions and clarifications over the coming months. If this video helped you understand what's changing, subscribe to this channel. Updates will be coming regularly as agencies issue guidance and as we see how these new rules are applied in practice. In the next video, I'll be breaking down the specific documentation requirements for the enhanced I-751 process, including exactly what adjudicators are looking for and what mistakes cause the most denials. Until then, take the time to assess your own situation. Gather your documentation, calculate your travel days, and make informed decisions about your next steps before these changes affect you directly.